True or false questions with the estate planning queen. If I end up in a coma or lose mental capacity, my next of kin can legally access my bank accounts to pay my mortgage and my care bills.
False. They can't access anything like that if you've not already completed, attested and registered lasting powers of attorney. If you lose capacity, if you're in a coma, you've lost capacity, you are classed as a vulnerable person, and everything can and often does get frozen. And nobody can unfreeze it or access anything like that without lasting power of attorney.
Estate planning is purely for the elderly or the wealthy.
That's false. Estate planning is for everybody. Everybody that has worked hard and built some assets up and wants to protect for their future, for their family's future. There's very, very normal families now that are finding themselves in inheritance tax liable situations just through normal situations, normal circumstances. And certainly as of next year, when pensions, drawdown pensions, pension pots are going to start forming part of an estate, it is crucial to get some estate planning in place.
Getting married automatically cancels out or revokes any will that I wrote before my wedding.
That's true, unless you had a will prior to getting married with an intention to marry clause in it. If you put that in your will before you got married, then the will remains. If you didn't have an intention to marry in the will, then the will is revoked by marriage.
Getting divorced automatically cancels out my will.
Well, no, that's false. It doesn't cancel the will. It just treats your spouse as having effectively deceased. So they are no longer of benefit in the will, but the rest of the will stays the same.
Stepchildren carry the exact same automatic legal inheritance rights as biological children.
That's false. Stepchildren do not carry the same automatic inheritance rights unless you adopt them.